My ladies, my lords, immediately before lunch we were dealing with Dr. Zabato-Bravo's evidence as recorded in the transcripts, and I gave the court reference to the passage which is at supplementary MS 335 line 19 through to 337 line 22. The exchange on 10 minutes and the sole source of the 10-minute point is at MS 336, page 60 of the transcript reference. It's really lines 17 through to 29. And the court will see that he says at line 24, yes, thank you. So the point is to state that I don't think they can. That's an answer to whether analgesia is the same as the unconsciousness that would have been produced by the shock in Dr. Zabato-Bravo's view. I don't think they can, but I think the shock, which may have occurred in this case, was longer for him to be burnt 4 times. The process, I try to imagine, would have required at least 10 minutes approximately, and no more than that is necessary for what happened, yes, but that is again speculative. So I think it's probably fair to say he doesn't know how long it would have taken to inflict the burns. He says it's speculative. Well, Justice Elias thought that he wasn't in a position to give expert evidence about how long it would have taken. But what he certainly seems to be, what is saying at line 25, I think there was longer for him to be burnt time. 4 times is long enough for him to be burnt 4 times. I mean, the court can see it. I can't make it grammatically perfect in any way. But he certainly isn't saying it's implausible that he was unconscious for long enough to be burnt 4 times, which is what he comes to, what the upper tribunal's view comes to. And all of this is speculation. Now, the upper tribunal say that no other expert demurred. That's true in the sense I can't find a record of anyone demurring, but it's not put to any of the others. It's not an issue that's explored in detail in the transcripts. It's not part of the Home Office case. The upper tribunal have constructed a view of the evidence which rests on this exchange about 10 minutes and puts it together with the speculation about how it's clinically implausible for my client to have remained unconscious for 10 minutes. And don't accept either limb. And if we go on to page 337, at line 14 through to 22, there's an exchange. This is again Judge Dawson saying at line 14, I am of your view that shock alone, which induced unconsciousness, would not be enough for that unconsciousness to be sustained, for the subsequent pain to be applied without waking the patient up. There would need to be something else. And then the question goes on, right, and you state that the sustained state of unconsciousness can be attributed to poor health and neglect. Yay. Yes, presumably. And your Lordship, ladies and my lords, will see the reference to line 23, dehydration at the time and poor nutrition. So there's nothing there to suggest that Zabato-Bravo thought it was clinically implausible. My client to have remained unconscious for long enough for the back injuries, the back burns, to be inflicted. The only other evidence that I think it's right to draw the court's attention to in the transcript dealing with Zabato Bravo is the exchange at supplementary MS page 340, page 64 of the transcript. This is Mr. Duffy exploring what would be necessary in the way of immobilisation. Your court will see the question at line 23. Ending up with the answer just over the page, top of page 341. Cause irregularities in the boundaries of the marks, which are so extremely neat that it militates against the idea that pure mobility could have been used for producing these remarks. So I accept that is Zabato Bravo, accepting that immobility alone will not explain the shape of the scars on his back, my client's back. Plainly not intending to go back on what he said about the scars on the arm, which are a central part of his report.
Well, the third line of the answer, specific reference to back.
Yes.
Yes?
Yes, indeed. That is, we've now seen Dr. Zabato Bravo's report and we've seen the transcript, and I repeat the submissions that I made about what he was saying about the scars on the arm and the back. And I repeat, importantly, the submission that it's all entirely consistent. There's no tension or inconsistency between them. It's a carefully crafted report recording an explanation for the difference between the scars on the arm and the back, which is consistent with my client's account, highly consistent with my client's account. Now that leaves me, in terms of the expert evidence, Dr. Adili and Dr. Allam. Dr. Adili is at her written evidence is at core volume 2, MS 1390, and I asked the court to go straight to 1392. Paragraph 6 of the history, H6, 1392, records my client's account, third line in. He says he saw a rod similar to that used on building sites. It was glowing red as if it had come out of a fire. Before he could react, it was pressed against his right arm. He says he screamed in pain and felt burning and became unconscious. He was not aware of receiving other burns to his right arm or back, as he was unconscious. He told me he was in a lot of pain when he regained consciousness on his back and right arm. They continued to ask him questions about where the gold was hidden. He says he was held by 5 to 10 people and could not fight them off. And then there's an account about petrol being poured on him and so on. So that is then that history is considered by Dr. Adili at opinion at 07, paragraph 7 of the opinion, paragraph 1395. Sorry, my mistake. MS 1393. And she says, in this case, it is not clinically possible to differentiate between scarring caused with consent and scarring caused by torture. in both of these scenarios, the method or cause of the burn is the same, and so the burn scar would be the same. The distribution of the scars and the type of scars would have required him to have been immobilized or unconscious to deliver the burns. The client reports that he was immobilized and that he was unconscious for most of the time the burns took place. Even if he consented to the burning, the pain would have been such that he would have had to be immobilized or he would have moved. The burn scars are so similar with no blurring or smudging. So Dr. Adili is certainly saying immobilization is enough for some of the scars. She doesn't differentiate between them, but for some of the scars, by immobilization, she presumably means, or plainly does mean, the factual situation she has recounted in H6, which we've just looked at, being held by 5 to 10 people. So actually, Dr. Adili's account is the same as Dr. Zabato Bravo's. He's held. She refers to that as being immobilized. She is burnt, becomes unconscious, and the burning continues. And she doesn't actually say that it looks as if the rod was hotter at the time of the burns on the arm. That's 01, paragraph 01, towards the top of MS 1393. The appearance of the scar on the left lower back is typical of a contact burn where the time of contact between the heated object and the skin was less than for the other 5 scars. Alternatively, a heated rod which is starting to cool down will cause less tissue damage and scarring than a newly heated rod. This would explain why the scars on the arm are slightly wider and darker, as these were the first reported areas of burning. So she is saying, actually, there's a difference between the scars on the arm and the back. One explanation is that the rod was hotter when the scars on the arm were inflicted. That's what my client says. The basic submission is that there's nothing in the opinion to indicate that she thought it was clinically implausible that the sequence of events that my client described took place. I think that's all I need from the report. We then go to the transcript. There's only one passage, so supplementary memory stick, supplementary MS 321. And it's line 10, MS321, line 10, through to the bottom of the page, line 34. This is being questioned by Judge Story. And the court will see the exchange at line 24 through to 34. And she is asked in terms at line 37, do you think, well, let me start again, do you think it's possible that he, with that kind of burn, would have been unconscious for any significant period or not? Actually quite difficult to tell because he does not recall being awake for other burns. he says that when he was revived, he felt pain on his back, so he could have been unconscious for a minute. If he fainted, for example, they may have burnt him with other objects to try to get him to wake up. Difficult to tell how long someone was unconscious for. If he was breathing, there would have been no need to rouse him. Once again, the negative submission, there's nothing, that's the exchange. There's nothing in the submission, in the exchange, to suggest that she thought it was the account, the sequence of events was clinically implausible. Last port of call on the medical evidence is Alam, once again in volume 2 of the core volume, at MS 1223. Her report starts at 1223. And if you just look at 1223, the report takes the form of a response to questions. It's apparent that she was not given any specific information about my client, his account, any information about what he said happened, or anything of that sort. She's just answered a series of rather abstract questions, as I think it was Lord Justice Elias described them. Again, the holding of the upper tribunal that my client's account was clinically implausible is constructed on the basis of the exchange in relation to question 6 at the foot of what MS 1225. The question reads, if someone faints from ill treatment, how likely would he or she regain consciousness if the same pain was inflicted again? And the court can read the answer. She's actually dealing with a rather different set of situations. She's dealing with response to insertion of intravenous cannulae on epidurals, for example. We're not talking about a torture scenario. She doesn't know what it is that my client said happened to her. But most importantly, what the passage ends up with, the last 5 or 6 lines, further appropriate response to a painful and unpleasant stimulation in the individual would then be likely to be seen again. That's where she said you would, once you fainted and laid down, you would recover. Then other factors, such as health, physical state of the individual, could affect the speed with which they regain consciousness or increase the propensity for further vasovagal response. Now, insofar as that's directed at all to our situation, it's not ruling out the Dr. Sabato Bravo's analysis, which of poor health, the matters that he would indicate the possibility of a longer period of unconsciousness. It's totally compatible with him. So that is the sum total of the medical evidence you see in all the reports, and you see in the bits of the transcript which I say are relevant, both negatively and positively, to the analysis we've put forward about them. Lord Justice Elias, at paragraphs 115 to 116 of the Court of Appeal judgment, dealt with directly with these issues. It's MS 925, page 43 of the CV1. And without reading it to the court, I just adopt that and that response to the medical evidence that we've just been through. The court will see the observation last 4 or 5 lines of 115. Even on that premise, there was still, in my view, no proper basis for concluding that the possibility of remaining unconscious following his fainting was an unlikely explanation of the fact that he had not woken up. In my view, the upper tribunal is here making a finding which it was not qualified to make. I do not accept that Dr. Allen's silence on the point justified this conclusion. We just looked at Dr. Allen. Or can read 116.
Reading ahead a bit, 116, 20 lines down, Lord Justice Elias says, the nature and placing of the scars provided strong prima facie evidence of torture, at least to the lower standard. In these exceptional circumstances, it was for the Secretary of State to establish that the obvious explanation for the scars was not in fact the correct one. Do you go along with a shift of the evidential burden onto the Secretary of State in this situation?
Not as a matter of hard law, but I think the reasoning of Lord Justice Elias is putting forward is that where you're confronted with only 2 possibilities, and where the burden is the lower burden of proof, then you have to say the SIBP hypothesis is not only unlikely, but did not occur on the current sort of approach. So the practical answer to your Lordship's question is yes, but it's a practical answer. That is where, as I understand it, is what Lord Justice Elias is saying. There's a passage in a Strasbourg judgment, which is very, very short, but which is on all fours with the sort of reasoning about the role of medical evidence and the conclusions to be drawn from it in torture cases, which I'll show you, Lordships, in just a moment.
Thank you.
But what it's sufficient for my purposes to say that it's not good enough for the Secretary of State to simply say, my client hasn't proved his case, when there is no other explanation than SIBP. That's what the tribunal actually does do. The tribunal says, well, it's not for us to find out what caused the scarring. Well, the essence of Lord Justice Elias's approach is that that's just not realistic in this binary situation. It might be realistic elsewhere. But in any event, applying the lowest burden of proof, my client wins even if the possibility is unlikely, unless it can be discounted. And as I understand it, that rather than a technical issue about described as a burden of proof is what Lord Justice Elias is saying. He's saying we have to approach this on the basis that there are two possibilities, and in that situation where one of them, SIBP, appears to be unlikely on the face of it, just prima facie unlikely, then you don't exclude the account of torture unless you actually discount the account of torture and therefore find it was SIBP. Leave yourself with no alternative.
That works when it's known for definite that there are only two possibilities.
Yes.
Doesn't work otherwise, does it?
And
it's not always possible to know if it's known, if you know what I mean.
I know exactly what you mean, and that's why, sorry.
I think one of the authorities is Poppy Magna,
Yeah.
about a shipping case about that.
Yes, that's why I'm answering in the way that I am answering. It would normally be, as Lord Justice Elias himself says, let's go back to the passage, it normally would be good enough for the Secretary of State to say, you haven't proved even to the lower burden that that there was a real risk of torture. Yeah. Let me just catch up with myself. Yes, it is. It's evidence, under the heading Evidence Relating to the Cause of Scarring, MS 921. He says, in my judgment, therefore, the central issue in this appeal is whether the upper tribunal's conclusion that the only real explanation for the injuries is that they were SIBP is sustainable, having regard in account, in particular, to the appellant's account of how the scarring was inflicted and the relevant medical evidence. I respectfully disagree with the observation that Lord Justice Sales at 78 to 79, where he states it's enough for the upper tribunal to find the appellant had not discharged the burden even to the lower standard of establishing that he had not been subjected to torture, and that it was not obliged to determine what the cause of the injuries was. That is, of course, generally true, but in my judgment, where the upper tribunal accepts that in excluding torture it is necessarily embracing SIBP, not only is it obliged to have regard to that fact, but it should give it considerable weight in its overall assessment. So, and it is the direct answer to my lady's question is that the upper tribunal thought there were only two causes.
I suppose what I'm really putting to you is that this is not something that one would want to build into a principle. It's dependent on the specific facts.
That's probably why I've been slightly hesitant about giving the answer to it. It's not an answer of principle. It's an answer on the facts of the case. The upper tribunal have reasoned itself into the conclusions at the end of its judgment. We were looking at these at 364. Well, it's 364.
Page.
MS 1021 and 1022.
Thank you.
I'm certainly, your ladyship will see that what the tribunal say, second line in, of these two real possibilities, we have found on analysis that the former claim, that is, torture, does not withstand scrutiny. Certainly we cannot say in his case the evidence inexorably points to SIBP, but given we have concluded it is left as the only real possibility that we have not been able to discount, taking the evidence as a whole, we are satisfied is not shown his account is reasonably likely to be true. So I completely accept that in most other cases, you will not have this complete binary choice between the account being torture or being SIBP with no other possibility, but that is the reasoning of the tribunal. And it comes back to the other point that Lord Justice Elias emphasises, which is you start with the fundamental improbability, just as a matter of common sense almost, of anyone subjecting themselves willingly to scarring of the sort that my client undertook. You start from there. You say, well, I can't discount it completely, but in order to reject the torture claim, I have to hold that it does not withstand scrutiny. And that's precisely what they do. And we say the torture claim does withstand scrutiny. That's a rather laboured answer, but that is the answer that I'm going to give. I'll have another think overnight, no doubt, and put it up. Right. Well, that is the medical evidence, and that's the heart of the case. A limited number of observations on matters of law. But as we explored this morning, I'm not sure that there's a lot of difference between ourselves and the upper tribunal on the approach to the role of medical evidence and expertise, which is one of the legal issues. In our printed case, we have set out at paragraphs 50 to 52 the background material relating to the Istanbul Protocol. I know that my learned friend, Ms. Harrison, will have some submissions about this. But if I can just highlight, possibly by reference to the document itself, some of the critical passages without spending a lot of time on them. If the court will go to MS 1307, which is in CV2, we are at 1307, MS 10307. We are in chapter 4 of the Istanbul Protocol. And there's a heading, Purpose of Inquiry, Examination and Documentation, in the left-hand column. 122 describes the purpose of the written or oral testimony of the physician is to provide expert opinion on the degree to which medical findings correlate with the patient's allegations of abuse and to communicate effectively the physician's medical findings and interpretations to the judiciary or other appropriate authorities. And then the end of that paragraph, the examiner should be prepared to do the following. And then A, assess possible injury and abuse even in the absence of specific allegations by individuals, law enforcement or judicial officials. C, correlate the degree of consistency between examination findings and specific allegations of abuse by the patient. D, correlate the degree of consistency between individual examination findings with the knowledge of torture methods in a particular region and their common after effects. Well, it's C is the straightforward statement of principle in the Istanbul Protocol. What you're looking for is for the expert to correlate the degree of consistency between the examination findings and the specific allegations of abuse by the patient. Very obvious submissions, that's good enough to mean that in Dr. Sabato Bravo's case, one of his jobs is to correlate what he found on examining the scars with the history of how they were inflicted, given by my client. That's what he's told to do. And that's what he does do. And then that's carried over into 141, page MS 1310, CV 2428, again, the examiner is told for each form of abuse, note body position, restraint, nature of contact, including duration, frequency, anatomical location, and the area of the body affected. Was there bleeding, head trauma, or loss of consciousness, etc.? All of which is done precisely by Dr. Zapato Bravo. And if one goes on, then...
This sounds to be, paragraph 141, a description of the sort of... Is this, if this is about what the expert's meant to do, it's a description of the sort of questions he's asking, isn't it? Because little of this would be available on a subsequent examination weeks or months after the event. The investigator should also ask about how the person was at the end of the session.
Yes, well, I've certainly read it as telling the person who's carrying out the examination.
Yes. But you can do so much by looking at what's left months later, and you can do so much by asking questions. Or my only observation is that just taking this paragraph on its own, it's mainly about a questioning process, isn't it?
Yes. Well, yes, I think in a way that's my positive point. It's the relevance of this issue is to the difference of approach between Lord Justice Sales and Lord Justice Elias. What the protocol is doing is envisaging that the examiner will ask questions about the history of the abuse. That's what 141 is about. And then correlate it in accordance with what is said in 122C with examination findings and specific allegations of abuse. Now, the specific allegation of abuse is the history. And if one goes on to, well, the central paragraph is 187 and 188. MS 1317. Following discussions is not meant to be an exhaustive discussion of all forms of torture, but it is intended, this is 187, it is intended to describe in more detail the medical aspects of many of the more common forms of torture. For each lesion and the overall pattern of lesions, the physician should indicate the degree of consistency between it in the attribution given by the patient. The following terms are generally used, then they're set out. And C is relevant, highly consistent. The lesion could have been caused by the trauma described, and there are a few other possible causes. And then we'll see typical of, and the ladies will see typical of. And then 188 summarizes it all. So ultimately, it is the overall evaluation of all lesions and not the consistency of each lesion with a particular form of torture is important in assessing the torture story. Now, that's a phrase that's used more than once in the protocol. And what you're looking for is an account, as I understand the protocol, is an account given by the person who says they've been tortured. And you're looking to correlate what you find on examination with that account. And some specific guidance or observations about burning in paragraph 194. MS 1318. Our submission is that Sabate Bravo was conscientiously applying the Istanbul Protocol, and in particular 187 and 188. Now, the other materials that are before the court all point the same way. If the court will pick up Authorities Bundle 3, tab 42, we are in, the court looks first of all at MS 660.
660?
660. It's at the heading at the very top of the page. We're in the International Association of Refugee Law Judges Guidelines on the Judicial Approach to Expert Medical Evidence. And the point about correlation is repeated. 661, paragraph 3.1. The role of expert medical evidence. And the second bullet point, there's expert medical evidence is obtained for one or more of the following purposes: to establish a correlation between physical and psychological injuries and the alleged torture or ill treatment. Same point about 3.2. Four through to 4.8, that's MS 664, 665. Four says, as a norm, third line in, the evaluation should include a description of how the injury was occurred according to the claimant, an opinion on the consistency between the nature of the injury and the manner in which it was incurred, preferably with precise reasons.
Mr. Drabble, as you have said, you appear on the face of it in your case to have assembled a wide variety of authority in support of your proposition about the entitlement of an expert to express a view about the correlation of the injuries that he sees with the story of torture given. One doesn't want to waste too much time on this. In the Secretary of State's objection to your grant of permission, which wasn't drafted by Mr. Sheldon, it was said, well, Sales LJ was entirely correct. But now, and Mr. Sheldon will correct me if I'm wrong tomorrow or later this afternoon, he's not really challenging much of what you say. He says instead, I think, two things. First of all, it's all Miss Harrison's fault, because she said that experts were entitled to say whether they believed the appellant. Well, over the short adjournment, we've been looking at her skeleton argument. In that, she did not say that. Perhaps in oral evidence, she did. We'll have to see. But the other thing that I think Mr. Sheldon is now saying is, well, it really, Sales LJ was making a very narrow point. Dr. Zapata Bravo didn't have the particular expertise which entitled him to make that correlation. So would you like to deal with that point?
Well, I mean, that is not what the upper tribunal say. The line of reasoning of the upper tribunal is that which they set out in paragraph
Yes, they don't make
6.4.
that point.
Well, yes, I've made the point already, but it goes back to the tribunal's own analysis of the material, which is to the effect that Sabato Bravo accepted. Their line is that a fair reading of Dr. Sabato Bravo's evidence is that we, the tribunal, should draw the conclusion that it was clinically implausible that my client would be unconscious through the periods of the burning. Now, they're not saying Sabato Bravo wasn't competent to make a finding about that. He did make it. Indeed, the tribunal explored it in the passages that we've already seen.
Yes. Very well, thank you.
Now, my Lord, I'm basically content to rest on the materials that we've referred to in our written case, on the appropriate approach. They are obviously important. Yes, I did say I would take you to RC Sweden, and perhaps I could, that's one of the Strasbourg cases. It's a very short passage. And it's at, if we pick up Authorities Bundle 3, tab 37, and the report starts at MS 572. And the passage is paragraph 53, MS 587. Firstly, the court notes that the applicant initially produced a medical certificate before the Migration Board as evidence of having been tortured. Although the certificate was not written by an expert specialising in the assessment of torture injury, the court considers that it, nevertheless, gave a rather strong indication to the authorities that the applicant's scars and injuries may have been caused by ill treatment or torture. In such circumstances, it was for the Migration Board to dispel any doubts that may have persisted as to the cause of such scarring. In the court's view, the Migration Board ought to have directed an expert opinion be obtained as to the probable cause of the applicant's scars in circumstances where he had made out a prima facie case as to their origin. It did not do so, and neither did the appellate courts. While the burden of proof in principle rests on the applicant, the court disagrees with the government's view that it was incumbent on him to produce such an expert opinion. In cases such as the present one, the state has a duty to ascertain all the relevant facts, particularly in circumstances where there's a strong indication that the applicant's injuries may have been caused by torture. The court notes that the forensic medical report submitted at its request has documented numerous scars on the applicant's body. Although some of them may have been caused by means other than torture, the court accepts the report's general conclusion that the injuries to a large extent are consistent with having been inflicted by the applicant, on the applicant by other persons and in the manner which he described, therefore strongly indicating that he's been a victim of torture. The medical evidence thus corroborates the applicant's story. So, it's another case, going back to our discussion about burden of proof, it says in terms the burden of proof in principle rests on the applicant. But you have to apply that in a pragmatic way, depending on the nature of the torture story, to use the Istanbul Protocol phrase. And where you come down to finding that there's a prima facie case of torture looking at the injuries, and Strasbourg is certainly contemplating that the state has a duty to ascertain all relevant facts in those circumstances. As I say, I'm happy to leave. I mean, there are other very important cases, Muranga, SA Somalia, and AM, but no, I don't feel a need to go to them unless the court wants me to at this stage. I reserve the right, if it's acceptable to the court, to come back to them, depending on the way the argument goes from now on. But otherwise, those are my submissions, I think. Yeah.
Thank you very much, Mr. Drebble. Mr. Toll?
Thank you, my lady. No.
Thank you. Ms. Harrison?
My ladies, my lord, it may be I was concerned that 30 minutes is going to be a struggle, but in light of the observations that we've just had, then it may be that my submissions likewise are very much more shorter. But as the court is aware, the three organisations that I represent are the leading organisations in the United Kingdom who are engaged in what the Istanbul Protocol says is a priority in terms of protecting individuals from torture, and that is the effective documentation of torture. That is their rationale. That is what the staff and the many volunteer doctors who work for them do. Their task is to document torture, not simply to document injuries or illness. And the judgment of the Court of Appeal below, in three fundamental respects, is seen by them, and we respectfully submit if it were to be upheld, would have the effect of very significantly undermining their ability to effectively document torture, because in three ways, the majority judgment between paragraphs 33 and 35, that's MS 899, MS 900, would have the impact of seriously undermining the value and function of medical experts in giving opinions, as my learned friend Mr. Drabble says, on the injuries or other symptoms if they were unable to carry out the task which we respectfully submit is mandated to them by the Istanbul Protocol, and that is to correlate the injuries with the account of torture, with the torture story. It's not simply a question, as Lord Justice Sales concluded in paragraph 34, make an assessment of the immediate cause of the scars, that's the last three lines on paragraph 34, or as we've described it in our case, on the mode of injury, but whether or not those clinical findings are consistent with the overall account of torture. It's that is at the heart of the value of a medical opinion, and it is that which the Court of Appeal in SA Somalia and other cases has concluded renders medical evidence of this type capable of corroborating or lending support to the account of torture. If that were not the case, therefore, that critical and key role that medical experts play in assisting tribunals to come to the correct decision as to whether or not the person does have a history of torture and therefore is at risk of ill treatment on return, would be seriously limited and undermined. The further way in which the Court of Appeal's judgment is of concern to the interveners is because it does, at paragraph 35 and paragraph 94, sideline the significance of the Istanbul Protocol in favour of the general guidance as to expert evidence, the practice direction. At paragraph 94, that's MS 919, the Court of Appeal suggests that the Istanbul Protocol is not authoritative guidance, it's the practice direction, and says, and effectively relegates it to something described as a reference resource. It's clear from the evidence provided and from the materials that have been amassed that the Istanbul Protocol is very much more significant and indeed central to the task of assessing claims of torture. And whilst the practice direction, of course, sets out the basic requirements of objectivity, impartiality, duties to the court, it cannot be and cannot begin to be a substitute for the very detailed authoritative guidance that has been given by the United Nations in drawing up and promoting the Istanbul Protocol as the effective means of documenting torture.
Is that a practice direction focused upon torture?
No, my lord, it's the general practice direction relating to expert testimony of any kind of expert evidence.
Yes.
And obviously, it isn't specifically related to medical experts, and it certainly isn't specifically related in any way, shape or form to the assessment and documentation of torture. And so therefore cannot be treated, we respectfully submit, as the primary source of guidance for doctors when they come to provide an opinion to assist the court in assessments of past claims of torture. Thirdly, and in respect...
Just pausing a minute, it is the practice direction, it is applicable to cases of this kind, as I understand it. The question is whether it overrides the detail of the protocol.
Well, my lord, our submission is that, of course, experts must have regard to the practice direction, and that's the foundation of any expert testimony to a court. However, when it comes to the methodology and the principles of assessing claims of torture, then clearly the Istanbul Protocol, which was designed and has expertise from many countries brought together over a 3-year period precisely to provide guidance on how you effectively document and provide medico-legal reports to courts, whether it's in the context of criminal prosecution, defence if there's an allegation of a confession obtained by force, or as in this context, evaluation of claims for asylum, then it is a specifically designed, tailored, extensive guidance as to how a doctor ought to go about carrying out that task, precisely for the purpose not just of following basic requirements of an expert witness, but how to effectively document and identify torture. That's its rationale. And so the suggestion that experts were giving too much credence as the authoritative source in the way in which they were carrying out their assessments and coming to their views and giving their opinion to the court, we respectfully submit was an aspect of the Court of Appeal's judgment that should be deprecated, because it's quite clear, certainly from cases following SA Somalia, that it is the methodology of the Istanbul Protocol that is the way in which medical evidence and medical opinions have been recognised to be corroborative of the account, because it does go through a systematic mechanism for obtaining the relevant information, and then crucially, once that information and the clinical findings and all other relevant matters have been obtained by the medical expert, they go about the expert task of correlating that information with not just what their clinical findings are, but with the account of torture. It is that process, critical to the Istanbul Protocol methodology, that is key to the Court of Appeal's recognition in SA Somalia and subsequently that medical reports of this kind have the effect of corroborating or lending support to the account of torture. And so to suggest to doctors that it's only a reference source, we respectfully submit does not do justice to the significance of that document, nor to the cogency of the evidence that can be obtained if its methodology is applied, and applied rigorously. The third way in which the interveners are concerned is the reference at paragraph 35 to a submission that's accorded to me that there's no part of the medical expert's role to assess the veracity of the account. I accept that the language that's recorded there is whether they believe the complainant's story. I have no recollection as to what exactly the words were used. I don't move away from those words, but the critical concern is that there is well-established case law that makes clear that in carrying out their assessments, it will be an aspect of a medical expert's role to critically evaluate the account and the story that they've given.
Excuse me, would that be only so far as it relates to the trauma that's been suffered, though?
To the account of torture, yes. Yes. So,
So far as the account of torture
yes,
is concerned with the trauma itself, that is a subject to which the expert can properly direct his or her attention. But is Lord Justice Sales perhaps looking at the wider aspects of the story, which may extend beyond the actual circumstances of the trauma?
First and foremost, in documenting torture, as we've seen, the medical expert will be assessing the consistency of the clinically significant findings with the account that has been given. That account is not limited to the mode of injury. That account includes the circumstances in which that injury occurred. In this context, we've explored what that is. It goes beyond that. It could also include the conditions of detention. It could include the surrounding circumstances in which the injury occurred.
Well, so far as they may impact on things like a risk of infection, that
Yes.
would again properly be within the subject matter of the expert's expertise.
Yes.
But I'm just asking myself whether or not Lord Justice Sales is here really trying to draw a distinction between those aspects of the story which relate to the trauma itself and are consequently within the expert's range of expertise, and those aspects of the story which are not.
Certainly, it was no part of our submission that a medical expert makes an assessment of the overall credibility of the claim. Of course, that's a matter for the fact-finding tribunal, and also the overall personal credibility of the claim. However, what we do submit is that there, and I'll take you to it shortly, that there is clear authority that in coming to their assessment of the account that they've been given, doctors can form, and often will form, a view on the credence and the truthfulness of the information that they've been given, applying their expertise, not obviously taking at face value what the individual says, but critically evaluating it by reference to all of the relevant material. It's an overall evaluation. There may be aspects of a doctor's findings that do demonstrate credence to the account overall.
Indeed.
And there may be aspects of the medical evidence that go to the question of credibility. So, for example, there's authority that makes clear that in the context of credibility findings, that have adverse credibility findings that could be made based on inconsistency, late disclosure, discrepancy, an individual who suffered torture, who may have sequelae, psychological sequelae, that might be an explanation for the way in which they've given their account over time. So there's a number of ways in which medical expertise and the evaluation that is undertaken carrying out the Istanbul Protocol approach, and indeed general medical practice, that can lead to medical opinions assisting the tribunal with their overall assessment. That doesn't usurp the function of the fact-finding tribunal. Of course, the fact-finding tribunal is always entitled to take a different view or not to accept it. But it should take into account, in the ways in which I've identified, both in assessing the torture story and in the wider context of the claim, relevant medical findings. And so...
Could you help me with this? Because in paragraph 32, Lord Justice Sales appears to be accepting a sensible form of categorisation for medical experts assessing injuries, and that categorisation includes, at E, the possibility that the appearance could not have been caused in any way other than that described. So
Yes.
Lord Justice Sales does appear to be accommodating within his reasoning the possibility that the expert evidence will in fact be directed to the plausibility of the story.
Well,
But it will depend upon the circumstances of the case before the tribunal.
it may depend upon, it certainly will, of course, but what is difficult, and we would respectfully submit that paragraph 32 properly does, and the properly understanding 187 of the Istanbul Protocol does have that requirement or that possibility within it. What is difficult to reconcile with Lord Justice Sales' acknowledgement of that in paragraph 32 is what he then goes on to say at paragraph 34 in stating that, this is in the context of Dr. Zapata Brava's assessment of the story being of highly consistent classification, that he has trespassed beyond his remit as an expert medical witness. We say that is contradictory to 187 for the reasons that your lordship says, and also 187 must be read in the context also of 188, which, as my learned friend Mr. Drabble says, it ultimately states in express terms that it's an overall evaluation of all lesions and not the consistency of each lesion with a particular form of torture that is important in assessing the story. So looking at 187 and 188 together, it certainly wouldn't, properly understanding those paragraphs, be correct to say that an expert has trespassed beyond his remit in making the highly consistent assessment that Dr. Zapata Brava did. And on behalf of the interveners, we say that is fairly and squarely within his remit. It is central to the efficacy of a medical examination carried out under the Istanbul Protocol in order to ensure that it does have the role for what it's intended, namely to corroborate or lend support to the account.
Or, of course, it could do the reverse.
Well, that's right, and there's certainly authority that a decision
it's
of
very important
Lord
to
Justice
recognise
Laws, yes, of course, in a case called
solely
MO,
designed to back it up.
I was going to take your lordship and my ladies to that authority because that's the point that Lord Justice Laws makes. It would be regretful, he says, if it wasn't within the remit of the doctor to identify evidence that's inconsistent or not supported by the account of the individual. That equally must be reported in accordance with the obligations of the expert and is a central part also of the Istanbul Protocol methodology and principles.
If an asylum seeker gets an unfavourable report, does he have to disclose it?
No, he doesn't.
As I read some of the evidence, if the examining MLR reporter comes to the conclusion that his report would actually, if he finished it, be adverse to the applicant, he just would stop at that stage. He wouldn't necessarily even go on and produce a full report.
I think in principle that would be correct. Obviously there are matters
I don't
of
think any
legal...
principles about it. I just picked it up as what appeared from the evidence of how they frequently operate. I don't mean it critically in any sense.
Yes, of course. Yes, and it wouldn't have to be disclosed for reasons of legal privilege, but of course it would not be proper or permissible for any person to advocate something contrary to that expert evidence, of course. And Your Lordship is right that the foundations make clear that they will only give reports in circumstances, positive reports, if they are satisfied that there's evidence that's at least consistent with the account. And that's part of the reason why the foundations have a special status recognised within Home Office policy in terms of the significance and the value of their reports.
Ms Harrison, before you move on, it strikes me, tell me if I've got this right, that the real fault line between your submission and what Lord Justice Sales was saying really focuses itself on the word trauma. If we look at paragraph 187 of the protocol, MS 1317, again and again in the subparagraphs, the draftsperson, whoever he or she is, or committee, is talking about whether the lesion could have been caused by the trauma described.
Yes.
And when you get to Lord Justice Sales, he's obviously distinguishing between the trauma,
Yes.
that is burning by metal rods, that's his interpretation of what trauma means in that context,
Yeah.
and who did it, when did it happen as part of a process of torture or some other process?
Yes.
What do you submit we take from the repetition of by the trauma described in sub A, sub B, sub C, actually all A to D of paragraph 187, and E is a bit more generally expressed?
We respectfully submit, yes, we respectfully submit that one shouldn't read trauma narrowly. That's a formula that doesn't have a closed meaning. It certainly doesn't, it would need to be substituted for the words that Lord Justice Sales used, which is the immediate cause. There's nothing that indicates that. It's open-textured in that sense. However, even if you were to read that as limited to essentially the mode in which the injury was inflicted or the symptoms occurred, you have to recognise, A, what's said at little e, as my Lord says, in a way, caused in a way other than that described. But moreover, and
well, except
critically...
that that's just expressing a different level of consistency, rather than a different test.
Yes,
Yeah.
but whatever one takes about 187, and even if one does construe it narrowly, it has to be read with 188, because that, having gone through that task, and in fact we saw exactly that task being undertaken by Dr. Zabata Brava. He looked at each lesion, at each injury, and he came to conclusions about it, and concluded that they were caused by the application of a hot metal rod, were diagnostic. But then what he then went on to do was to look wider than simply the trauma or the way in which the injury was inflicted, which is 187, to apply 188, and gave an overall evaluation of the lesions, and not just the consistency of each lesion with the torture story. So that's why his assessment went from diagnostic in terms of the cause of the burns on the back to highly consistent when it was put together with the account of the manner and the way and the circumstances in which the injury was inflicted upon him. And so
I wonder whether you could add to your answer to my Lord a reference to paragraph 172 of the Istanbul Protocol, which we've got at 1315. You have that to hand.
yes, my Lord, at
You see the first
1315.
sentence: torture victims may have injuries that are substantially different from other forms of trauma. So this is all drafted on the basis that torture is a form of trauma.
Yes. ultimately, it is a mistake to also take out of context 187 and 188. I think Mr. Drabble started the task of looking at the protocol as a whole. And when one does that, one can see that there is no justification for in any way limiting the task of the doctor applying this methodology to simply mode of injury. That is clear, and rather than go through them now because of time, but if I could ask your lordships to look at paragraph 83, that's MS 1300, which talks about an interpretation of the probable relationship of the physical and psychological findings to possible torture, to 105, again requiring the doctor to assess physical and psychological findings consistent with the alleged report of torture. Mr. Drabble has showed you 122 and the requirement to correlate. If you then go through the paragraphs that set out in detail how a doctor goes about obtaining the evidence and documenting the background, it is an extensive process between 136 to 145. It is taking a full narrative of the account of events. It's looking at the background. It's looking at the country conditions. For those who are specialists in documenting torture, there is knowledge about the forms and methods of torture that are used in particular contexts. We heard this morning that burning of the kind that this man has is known to be a practice of the Sri Lankan authorities. Those would be all the kinds of factors that a doctor would take into account in coming to his overall assessment, and the Istanbul Protocol tells the doctor the sorts of extensive inquiry that needs to be made. If your lordships can also look at 162, which again identify the need for there to be consistency with the account of torture and other forms of ill treatment having to be recorded by the doctor. At 169, again, there's a reference to the regional practice and correlating it with individual allegations and the requirement for a complete physical examination. That's at 173. All of that takes place as the context in which you then apply paragraphs 187 and 188. But it would be meaningless if you were simply asking what was the mode of injury, if you didn't have to look at it in the context of all these many factors and obtain a detailed account of torture.
I just interrupt you for a moment. When you say, for example, the frequency with which this particular kind of torture is said to have occurred in one particular country,
yes,
you say that is a matter upon which the doctor can express a view.
It's a matter he can take into account if it's within his knowledge. Doctors who
Indeed.
carry
So
out these
you'd qualify that. It must be within
Yes.
within the doctor's own personal professional experience.
Yes, and because these are doctors who document torture on a regular basis, and it becomes part of the fund of the knowledge. It's one of the duties under the Istanbul Protocol precisely to document systemic practices of torture so that it can be identified and steps can be taken to seek to eradicate it. And it's explained in Dr. Cohen's evidence that Sri Lanka has been frequently one of the highest producing countries of torture victims, and they're a very large portion of their clientele. So there is a knowledge. That's why there is evidence that burning of this kind is a known practice in Sri Lanka. The point of making reference to that is to indicate that there's no way in which the doctors, if he's appropriately qualified and he has access to that information, is going to disregard that and focus only upon the way in which the injuries were inflicted. It's important to also recognise that the same approach is adopted when it comes to psychological evaluation. And again, if your lordships can take note at 261 to 288, that's beginning at MS 1331, the approach is the same. That the doctor makes a findings as to the consistency of the psychological symptoms with the alleged report of torture, and then at 288 mirroring 188 in respect to physical injuries, is asked then to correlate those psychological findings with the alleged abuse. So there's a parallel with regards to the way in which doctors are asked to also assess psychiatric and psychological injury. I would also ask your lordships to look at the appendix to the Istanbul Protocol. That's at MS 1341, requiring interpretation as to the probable relationship of physical and psychological findings to possible torture or ill treatment. And you'll also see a template for how doctors should report their findings on consistency at MS 1355. So we respectfully submit that it's clear that the approach to the Istanbul Protocol in the judgment below is incorrect at paragraph 34. We would ask the court to look at the position that's taken by the Special Rapporteur on Torture in a relatively recent interim report, which supports very clearly the submissions that we make as to the nature of the task undertaken by a clinical expert assessing torture. And that is at volume 579.
Beg your pardon, could you please give me that reference again?
It's volume 579, and that's MS 1015. It may be looking at the time that all I can do is give you the references now so that I can show you some brief case law that I'd indicated that I would. But it's 579-1015, and if the court would have regard to paragraphs 19, that's MS 1018-19, 38, MS 1025, 52, MS 130 to 131, and 59, concluding at 1033 that good reports include analysis and interpretation of findings in terms of consistency with alleged events. We say that's an authoritative indication of how the Istanbul Protocol should be viewed. We have provided to the court a witness statement from one of the principal organisers and authors of the Istanbul Protocol, that's Mr. Yainapa, and his report is at Supplementary Bundle 4A, MS 113 to 131, and we'd ask the court in particular to look at his paragraphs 19, 34 and 35. In particular, his conclusion at 35, that's MS 126, that a medico-legal evaluation that fails to assess and give an opinion on the possibility of torture are not compatible with the IP and should be considered deficient. He goes on to explain the way in which the Istanbul Protocol works at 38, 41, 44 and 45. We respectfully submit that those sources of authoritative explanation of the Istanbul Protocol is fully reflected in our domestic case law. The key case, which is recognised as a landmark case, is SA Somalia. That's in Core Authorities 3, where it was also recognised by the Court of Appeal in the judgment of Sir Mark Potter at 26, MS 24, that where there is an opinion on consistency between presentation and attribution, that does have the consequence that the explanations given are true. So if one looks at paragraph 24 in MS, the Court of Appeal recognised that this approach, applying the Istanbul Protocol, does assist in determining the truth of the account that's been given. key paragraphs are 24 to 32, and it's important to recognise that the Court of Appeal in SA Somalia did take the view that it is not for decision makers to assess consistency and alternative causes, for example. That is a matter within the remit of the expert.
You are
Can I-
out of time, Miss Harrison.
Yes, can
by
I?
some way, but
I thought, oh, sorry, I was looking at
by
half
5
past
minutes.
3. Can I just then address this issue of truth and belief? And I can just give you the authorities that do expressly say that certainly in deciding whether a medical report can be considered independent evidence of torture, a clinical assessment which is critical and independent, where the doctor forms a belief that the account is true and is to be believed, it is acceptable. And that's the case of MA Angola, that's Court of Appeal 6, at paragraphs 29 to 31, and that is endorsed by the tribunal in JL Medical Reports Credibility. That's a Core Bundle 8, which makes clear that the approach in AM is not confined simply to cases of detention-related cases and independent evidence of torture, but applies across the board, and that's paragraph 34, MS 96.
What's the page reference to the Angola case?
My lord, my lady, the reference is MS 55.
Thank you.
Yeah.
And the key paragraphs are at MS 94 to 96. The authority where Lord Justice Laws recognised the significance of being able to identify inconsistency is the case of MO Algeria, that's 458, MS 606, paragraph 18 at MS 612. The two other authorities which I could give you the references for that make the same point about experts evaluating the account that's given is Y Sri Lanka, that's A460, MS 623, paragraph 12, and finally RM 451, MS 401. Mr. Justice Moses, as he then was, in characteristically straightforward terms, saying that doctors in that context, psychiatrists, do use their critical faculties to decide whether or not they're being spun a yarn. Whether that means they're believing the account or simply rejecting it as not truthful or not consistent, it's clearly an aspect of an expert's assessment and within their expertise to make an overall assessment of the account that they've been given.
I'm sorry, Miss Harrison, I really
Yes,
must stop you.
You must, that's right.
It's not fair to
No, of course.
Mr. Sheldon to let you
Those
continue.
are-
And
those-
indeed, you have provided us with a very full written
Yes,
argument
yes.
in any event.
Those are my submissions.
Thank you very much.
Mr. Sheldon.
My ladies, my lords, as to the structure of my submissions, I propose to start this afternoon, if I may, with some brief submissions as to the approach of the appellate court to findings of a specialist tribunal in a case of this nature and the extent of the duty to give reasons. Then to deal against that background with the specific criticisms that Mr. Drabble makes of the reasoning of the tribunal in this case in respect of the medical evidence it heard. And then finally to address the question of the proper remit of a medical expert in asylum claims involving allegations of past torture arising from the comments of Lord Justice Sales to the effect that one of the experts in this case trespassed beyond his remit, and to attempt to identify what, if anything, exists between our position and those of my learned friend Miss Harrison and indeed Mr. Drabble. Before turning to the issues of principle concerning the role of the appellate court and the duty to give reasons, I wonder if I might just identify at the outset the essential analysis of the tribunal which we submit was the basis of their conclusion and to which these principles apply. Having undertaken an extremely thorough review of the evidence, the core reasoning of the upper tribunal, the central findings upon which their decision rested, was that the marks on at least the appellant's back must have been caused when the appellant was unconscious, and that it was not clinically plausible that he would have remained unconscious, having fainted due to the initial infliction of pain, whilst the heated rod was applied to his back on further occasions. And it is our essential submission that on a proper application of the principles to be applied by an appellate court when reviewing decisions of a specialist fact-finding tribunal, and on a full and careful review of the evidence before that tribunal, that was a finding the upper tribunal was entitled to reach. Or, perhaps put differently, Mr. Drabble fails in our submission in his task of demonstrating that this was not a finding that the tribunal was entitled to reach. Could I start then with the issue of the approach of the appellate court to the evidential assessment by a specialist tribunal? And we make three submissions under this heading. The first is that the upper tribunal correctly directed itself on the law. It identified the correct question, it applied the correct burden and standard of proof, and it approached the assessment of the medical evidence in the correct manner. The second submission we make is that it reached a conclusion on the evidence which was open to it, and which was not, and is not in my submission contended to be, perverse. And thirdly, in those circumstances, the appellate court, which has not heard the evidence, should be slow to interfere with the conclusions of a specialist tribunal and should be astute to recognise attempts by a party to re-argue the merits of the evidence under the guise of an attack on the adequacy of reasons. And if I may, my lords, my lady, I'll take those submissions in turn. As to the upper tribunal's self-direction on the law, the fundamental question for the upper tribunal to address, this being an asylum case, was whether the appellant faced a real risk of persecution on his return to his country of origin. It's always the ultimate question on a claim of this nature. In this case, as in many, an assessment of future risk will depend largely on findings made in respect of past experience, and in particular whether the individual has suffered persecution in the past. Now, of course, prior to Karanakaran, it was thought that only those elements of past experience which could be established on the balance of probabilities could be included in the analysis and assessment of future risk. But Karanakaran made clear that this was not so, and all matters of evidence should be factored into the assessment of future risk, unless the decision maker had no real doubt that they had not in fact occurred. And the reference, if it's needed for that trite proposition, is tab 14 of the authorities bundle at MS 178 to 179. Now, that approach is accurately reflected in paragraph 320 of the upper tribunal's determination, which is found at MS 1011 at page 128 of the first volume of the core bundle. And my essential submission is that the self-direction on the law that the tribunal gave itself at paragraph 320 is impeccable. They correctly identified that the question they had to address was whether there was a real possibility that the appellant had been tortured by the authorities in the way that he claimed. Now, clearly, some matters of past fact will be more important than others when it comes to assessing future risk. And in this case, the tribunal correctly identified that it would almost inevitably follow that if there was a real possibility that the appellant had been tortured in the way he claimed, then he would clear the threshold of establishing that he was at real risk of persecution on return, as someone of such adverse interest to the authorities that they had been prepared to inflict very serious harm on him. So
are these two the same thing? Sorry to interrupt you.
No, not at all, my lady.
I'm looking at 320. Talks about the lower standard, and then assess, therefore, whether the account the appellant relies on is reasonably likely to have occurred, or, putting it another way, whether there is a real possibility that the events claimed happened. Now, the reasonably likely rather sounds like balance of probabilities that it did, whereas real possibility is a lower standard. Now, I may be... You're saying they were right to say real possibility.
I was, my lady, and I'm also saying that the insertion of the word reasonably before likely is also important. If they had simply said likely,
yes,
then I accept that would look like a straightforward...
Likely is also an ambiguous word, so...
Well, my lady, perhaps reasonably likely translates to reasonable likelihood, which would be another way of saying reasonable possibility. And so that's why I say that the insertion of that word is important. But in any event, any potential ambiguity over reasonable likelihood or reasonably likely is cleared up by what they then go on to say of real possibility. And then, as I'll come on to show in just a moment, they adopt the language of real possibility, as you have already seen at page 364. So what they are doing in my submission is, first of all, identifying correctly what the standard is per Karanakaran. And secondly, identifying quite correctly that of all the evidence in this case, the crucial piece of evidence is whether it is reasonably likely, or there is a real possibility, that this appellant had been tortured in the way that he claimed, because they rightly identify that that would almost inevitably get him home on the lower standard applicable in asylum cases. And so they identified, in short, the correct question. They also correctly identified, again at paragraph 320, that in answering that question, they had to consider the evidence as a whole, including the medical evidence, and not to compartmentalize different elements of the evidence. In other words, they recognized that they must not commit the error identified by the courts in cases such as Mabanga and SA Somalia of reaching a conclusion on credibility and then having a look to see if the medical evidence somehow turned the oil tanker around. They were aware that that was wrong, and they directed themselves, unsurprisingly, not to do it. And I say unsurprisingly because they were referred expressly to SA Somalia by the interveners. It's at paragraph 211. And they refer to SA Somalia at paragraph 314.
Well, it's inconceivable that Upper Tribunal Judge Story would not have been aware of that anyway.
Of course, my lady. And I raise it only because Mr. Drabble, admittedly by a sidewind in the course of his submissions, appeared to suggest this morning that they had made the Mabanga error, although he said, I'm not going to hold it greatly against them. In my submission, they clearly didn't, because if one looks at paragraph 337, which was the paragraph to which he directed you in this regard, which is at MS 1015, they expressly say that we turn to address the medical evidence relating to his scarring, which has informed our overall assessment in entirely orthodox SA Somalia terms. Now, the final element of the upper tribunal's self-direction, which again in my submission was entirely correct, was that notwithstanding the lower standard of real possibility, which clearly applies, the burden of meeting that standard was on the appellant. And that is why the formulation they adopt at paragraph 364, which is at MS 1022, at the end of the paragraph, namely that we are satisfied that he has not shown his account is reasonably likely to be true, was the correct formulation. And at paragraphs 13 and 14...
And you say we have an internal dictionary to show what they meant by reasonably likely.
Yes, my lord. And we set out at paragraphs 13 to 14 of our written case, which I adopt but don't repeat, at MS 841 to 842, the line of authority which says, in a nutshell, the burden of proof in an asylum case rests on the applicant from start to finish.
It becomes quite difficult, though, doesn't it, to see how that works when you're working on what is said to be a finite pool of possibilities, because they pick holes in the torture possibility and then say, and we can't say that the evidence inexorably points towards the other possibility, but do they go on to attempt to pick holes in that possibility?
Well, my lady, not expressly, I accept that. But what they do, and I'm going to come on in just a moment to the case of MA Somalia, in which Lord Dyson says in my submission they were exactly right to do this. What they do is ask themselves the straightforward question of whether the appellant has discharged his burden of proving to the lower standard that he was tortured in the way that he alleges. And they conclude that he has not discharged that burden, with the result that the only possibility that they consider to be a real one that is left is SIBP.
But how can they say it's a real possibility unless they've examined that as well? And if it isn't a real possibility, how doesn't that inform their view of his case?
Well, my lady, in my submission, they've identified it as a real possibility on the evidence, and they've explained why they consider it to be a real possibility on the evidence. And the essential elements of the evidence that they rely upon to support their conclusion that it is not just a real possibility, but the only real possibility left, are the ones I identified at the outset, namely the precise delineation of the scarring, which indicates he must have been unconscious, and the clinical implausibility of him remaining unconscious in the manner that he had described.
Well, then it's vital that those are accurately assessed by them. So if it wasn't, for example, delineated in all cases, that would then start to be a point in the column against this being inflicted by proxy.
Well, I of course accept that it's important that they provide proper and adequate reasons for their decision. But in my submission, they have. They analyse the medical evidence in a way that we'll look at in detail in just a moment, in a manner which I submit was entirely open to them. And they support their conclusion by reference to that evidence in a way that they were entitled to do. And by that process of reasoning, legitimate process of reasoning, they reach the conclusion they reach at paragraph 364, which was that this was the only real possibility left standing once the evidence had been rigorously assessed.
Developing Lady Black's point, but expressing it in abstract terms, Mr. Sheldon, if there are only two possibilities about what happened, and if the first is rejected, surely that decision means the second happened. Is there not a bit of intellectual dishonesty about the suggestion by the upper tribunal that they don't say that the evidence inexorably pointed to CIBP? Isn't that the inevitable conclusion?
My Lord, I don't accept that there's any intellectual dishonesty on the part of the tribunal. My submission is that the approach they took was entirely orthodox within the asylum context and properly took account of the principles that apply in the burden of standard of proof in this context. And to make good that answer, could I take the court briefly to the case of MA Somalia, which in my submission goes some way to assist in illustrating both the correctness of that proposition and also how it applies in practice. And it's in volume 2 of the authorities bundle at tab 25, MS 325.
Is it MA Somalia or is it MA Somalia?
Oh, I assumed it was MA, but your ladyship is quite right. There's a small a, so it may well be MA Somalia.
Was it?
Oh, Mr. Drabble, who was in it, and therefore will know better
So
than me.
he should know, yes.
Tells me it's MA.
So that's a misprint, obviously.
Yes. Very briefly on the facts of this case, if I may. The appellant was a failed asylum seeker of Somalian origin who had been granted indefinite leave to remain. He arrived in the United Kingdom in 1995, but was convicted of a very serious criminal offence in 1998, and so spent most of his time in the UK in custody, either pursuant to his sentence or immigration detention. And his claim was that return to Somalia would be a breach of Article 3. Now, the background evidence before the court was to the effect that return to Mogadishu would give rise to an Article 3 risk unless the applicant had powerful contacts in the city to whom he could turn for protection. So the critical question was whether the appellant had such contacts, or more precisely, whether he could show there was a real possibility he didn't. Now, the difficulty that the appellant encountered before the tribunal was that he was found to be thoroughly dishonest in all his evidence, such that the tribunal felt that they were unable to accept anything he had to say, including his assertions that he didn't have any contacts in Mogadishu. And the AIT's analysis in material part is at paragraph 38 of Lord Dyson's judgment, which is at MS 337. I wonder if I might ask the court briefly to turn that up. At paragraph 105, the tribunal directed itself quite correctly on the case with regard to the case of GM Eritrea, reminding themselves that they must be careful not to dismiss an appeal just because the appellant has told lies. However, at paragraph 108, they say, we are not able to find positively that the appellant is a person with close connections with powerful actors in Mogadishu and so on. The difficulty is the appellant hasn't told us the truth about his links and circumstances in Mogadishu, and we cannot exclude the possibility he is a person with connections of this kind. Over the page at the bottom of paragraph 119 on 338, they acknowledge in the last sentence that this appellant is going to be at risk if we accept his evidence of having no contacts in Mogadishu. We don't accept his evidence about that. He was manifestly untruthful. And then finally at 121, the burden is on the appellant, and he has not told the truth about his links with Mogadishu, and we are not able to say he is a person who has shown he would be at risk there. Now, just before I turn to Lord Dyson's analysis of this reasoning, the issue was a binary one in MA Somalia, just as it might be characterized to be a binary one. In this case, there were only two possibilities. Either he had contacts in Mogadishu or he didn't, just as this appellant was either tortured or he wasn't. And the essential conclusion of the tribunal was that because he was untruthful, he had not discharged his burden of demonstrating, even to the lower standard, that he did have that he did not have contacts in Mogadishu. And Lord Dyson's analysis of this decision starts at paragraph 42 at MS 340. And may I, my lords, my ladies, in due course commend the whole of paragraphs 42 to 50 to the court, but just very briefly pick out, for present purposes, one or two of the key points. The starting point in my submission, importantly, that Lord Dyson identifies at paragraph 42, is that it's important to note, he says, what the Court of Appeal didn't say. They did not say that the AIT had misdirected themselves as to the correct test to be applied, whether in Article 3 cases generally or the impact of lies. In other words, the AIT had directed itself correctly on the law. He then, at paragraph 43, said that in cases of this sort, one should always bear in mind the remarks of Baroness Hale in AH Sudan, and he reproduces those familiar remarks about the function of the specialist tribunal, the particular demands upon them, and the need for restraint by the appellate court in those circumstances. Then at paragraph 44, he identifies the role of the appellate court. The role of the court is to correct errors of law. Examples of such errors include misinterpreting the convention, misdirecting themselves by propounding the wrong test on some legal question, such as burden or standard of proof, procedural impropriety, breach of rules of natural justice, and the familiar errors of omitting a relevant factor or taking into account an irrelevant factor or reaching a conclusion on the facts which is irrational. And then the warning at paragraph 45 not to mistake disputes about the facts or conclusions on the evidence as errors of law. And then this, if I may flag up in paragraph 46, and for these purposes, before I turn to paragraph 46, I should perhaps just observe, of course, that Mr. Drabble, who appeared for the appellant in this case, had persuaded the Court of Appeal to set aside the decision of the AIT on two grounds. Firstly, he said that although they had directed themselves correctly on the law, they had in fact done what they said they wouldn't do and just dismissed the case because they thought he was a liar. And secondly, he said, there was clear evidence before the tribunal that this individual would not have contacts in Mogadishu because he'd been in the UK for 15 years and spent most of that time in prison. And so he said the tribunal was not entitled to reach the conclusion it reached. And with that in mind, Lord Dyson says at paragraph 46, in light of the clear and impeccable self-direction and having regard to the need to restraint to which we've heard, the court should surely have been very slow to reach the conclusion it did, the Court of Appeal. It should only have interpreted the paragraphs in the way it did if there was no doubt that this is what they meant. It's often easy enough to find some ambiguity or obscurity in a judgment or determination, particularly in a field as difficult and complex as immigration, where the facts may be difficult to unravel and the law difficult to apply. If a tribunal articulates a self-direction and does so correctly, the reviewing court should be slow to find that it has failed to apply the direction in accordance with its terms. And then to deal, I hope, more directly with the point my Lady Black put to me at paragraph 47. 4 lines down, in our view, all that the AIT were saying at paragraph 9 was that because MA had not told the truth about his links and circumstances in Mogadishu, the possibility that he was a person with connections in Mogadishu could not be excluded. In other words, he had not discharged the burden of proof which the AIT had correctly said rested on him. And then further at paragraph 48, they were saying that because he had told lies, They were unable to make any relevant findings and the appeal failed because MA had not discharged the burden of proof. 49, he spent 12 years in prison. No explicit reference to this fact, but the AIT were well aware of it. They said that they'd considered the evidence in the round, 122 paragraph determination, and so I reject, essentially, the suggestion that they hadn't taken it into account. Now, my lords, my lady, as I submit, this was essentially a binary question. He either had contacts in Mogadishu or he didn't. And Lord Dyson is explaining in this judgment, in my submission, that the correct approach, even in that binary situation which was put to me, is to ask whether the appellant has discharged the burden of proof on him that the possibility he relies upon is established. Now, that doesn't require, in this case, a positive finding about his contacts in Mogadishu. It didn't require the AIT positively to conclude that he had contacts or identify who those contacts were or how he might have established them even though he was in prison or what means of communication he might have used. It didn't require them to, as my lady put it to me, unpick that finding. It just required them to find that on the evidence that they had heard, he had not discharged his burden of proof of showing that he didn't have any.
That was a fundamentally different situation because in that situation, it was rejected because he'd lied. Here they're faced with two more or less improbable causes of the marks seen on the appellant. It's not the same as a simple, he has lied, therefore we reject what he says. He hasn't established it, he hasn't satisfied us. They're picking holes in the specifics of what he's put forward in the present case.
My lady, I of course accept that distinction, but in my submission it's not a distinction which undermines the principle. The principle that is reflected in paragraph 364, which I say is a correct direction of law, and I don't, for my part, understand Mr. Dreville to say otherwise, is that the tribunal analysed this in entirely conventional refugee asylum terms as whether the individual had discharged his burden of proof to the lower standard. And in expressing themselves in those terms, they expressed themselves correctly and in an orthodox way. They didn't have to make findings of fact on the balance of probabilities or otherwise as to what alternative possibilities might be true. The distinction that my lady accurately identifies of saying that this individual was dismissed as a liar from start to finish, whereas our appellant, the tribunal didn't quite go that far. I mean, they attack his credibility in wide-ranging respects, but they don't say, we can't believe a single word you say, and it's a bit more sophisticated analysis than that. It doesn't justify a difference in approach, and doesn't, in my submission, support the charge that the tribunal was being in any way intellectually dishonest in the way in which it approached the burden and standard of proof. My lady, I wonder if that might be...
That sounds like a very appropriate point at which to pause. We'll adjourn now and look forward to hearing from you further at 10:30 tomorrow morning.
Thank you very much.